Ladies and gentlemen, I'm Khaled and I will be your host for this session. Good afternoon and welcome to our webinar, Litigate in India during the lockdown, How are courts hearing the case? An interactive session with Justice A K Sikri, retired Judge, Supreme Court of India. The session will be presented by Vyapak Desai, Moazzam Alipak Banerjee, and our guest speaker, Justice A K Sikri. Please note that this session will be in listen-only mode and will last for about 16 minutes, for which first 30 to 40 minutes will be spent on panel discussion and the remaining time will be available for Q&A. Requesting all the participants to post your questions in the chat window while the panel discussion is on. The moderator will queue up the questions for the speakers accordingly. Should you need any assistance during the conference call, you can use the chat option. Do note that the conference is now being recorded. I now welcome our session presenter, Justice A K Sikri, retired Judge, Supreme Court of India, Vyapak Desai, Head, International Dispute Resolution and Investigations Practice at NDA, Moazzam, Leader and Head of Global Litigation at NDA, and Alipak Banerjee, Leader, International Dispute Resolution and Investigations Practice. Over to you, Vyapak.
Sure. Thanks, Khaled. First of all, thank you everyone to join this session. I think we are very, very excited to hold this session, particularly in the times when the whole scenario as to how litigation will be run in India during COVID, and more importantly, even beyond that, is going to dramatically change. This is the first time this kind of disruption is happening in the litigation and the justice system. So we thought this may be the right time to hold this webinar on this topic. And with the kind of audience that we have got today, which is in the range of 400, 500 participants, I think we were right to think that this was the right topic to debate. And who other than Justice Sikri to join us and discuss this issue. As we all know, Justice Sikri has retired from Supreme Court last year, but has been even more active with all of us. And we have been very, very, helpful in that sense with his guidance that we get so far as his contribution to the judiciary and the arbitration world today is concerned. He is also appointed as the international judge at the Singapore International Commercial Court, which means the Indian flag would further go high so far as the commercial decisions and jurisprudence goes in the international contracts and international jurisprudence. With that introduction to Mr. Sikri, I also have my colleagues Moazzam and Alipak with me, and we would discuss as to what it takes today to do an online litigation, particularly now, and how does it help to resolve some of the backlog and some of the issues that we know are there in our system in terms of process of delivery of justice. With that, let me first ask a question to Alipak to just give a little bit of a background as to where do we stand today in the times of COVID. We all know courts are not functioning to its maximum efficiency, but there are notifications issued for video conferencing. There are notifications issued to approach the courts for urgency and so on and so forth. So maybe Alipak, if you can give us a little bit of a background as to where we stand today.
Thank you, Vyapak. I think I will cover three aspects. I'll briefly touch upon how the courts are functioning and also two important orders which have come. One extending the limitation of cases by the Supreme Court and also the extension of interim relief already granted by the various high courts. Now, let me first touch upon the extension of limitation bit. So on 23rd of March, the Supreme Court took a suo motu cognizance and extended the limitation in respect of filings, in respect of courts and tribunals, irrespective of the limitation prescribed in the special or general laws in place. Now, that extension was granted for 4 weeks. We'll now see towards maybe next week what the Supreme Court does. Possibly they'll extend it further. So that immediately brings a relief to all the litigants, that they will not have to be worried that because they are not able to approach a court, that the limitation of filing a case will expire. So to that extent, this is a welcome development, and Supreme Court has taken care of this aspect. Now let me briefly touch upon how the courts are functioning. I think first I'll touch how Supreme Court is functioning, and then I'll move on to Delhi High Court. As you rightly pointed out, only exceptionally urgent cases are being taken up. The Supreme Court is roughly hearing about 12 to 14 cases every day. Not final hearings, these are more or less interim hearings. There's a detailed guideline and procedure which has been prescribed by the Supreme Court. The guideline came out yesterday, whereas the validity of video conferencing and the hearings, that was published by way of an order on 6th of April. Firstly, now let me explain how the hearings are taking place. What is the process? Now, when a litigant or an advocate on record, they have to first file a case. Along with, after the case is filed and it is scrutinized, they have to also file a one-page mentioning application explaining the grave urgency in their case. Once the application is approved by the registrar, the cases are taken up. It takes about 2 days for the effective hearing. The cases are published in cause list, and video links are provided to the litigants. The Supreme Court is using a platform called Video Platform, and there's a detailed guidance on that. Now, the parties can either log on to that system from their laptop or their mobile phone, or they could go to Supreme Court, and there is a facility available in the Supreme Court. From there, the hearings can take place. Now, during the video hearing, there are rules as well. The counsels are not expected to argue simultaneously. They'll have to argue at their turn. There is a stipulated timeline which has to be followed. These are basically the international practices that we see in Singapore, Hong Kong. We are now seeing similar interpretation, similar implementation in India as well. So the idea is to get a process in place so that the hearings take place in a very professional manner. Now the process is similar for High Court as well. In High Court, if a case is urgent, that has to be mentioned before the registrar. If the registrar accepts, the matter gets listed the very next day. If the registrar declines, there's another opportunity. You could file an application, and that application is heard by a judge of the High Court. Otherwise, even before the hearing, half an hour before the hearing, they'll set up a WhatsApp group taking all the mobile numbers of the litigants and the advocates. Then the video links are provided, and people log on to that and proceed with the hearing. Now, the last aspect which I want to explain is extension of interim relief. Now, the Delhi High Court was the first High Court in that sense to extend all the interim reliefs subsisting on 16th of March until 15th of May. Subsequent to Delhi High Court's order, Bombay High Court, Karnataka High Court, Kerala High Court, and various other High Courts have also done the same thing. The extension has been granted till about 30th of April. And with the given situation, we see that these extensions may be granted further. Now, the last aspect which I will consider, which I wanted to explain, was the Supreme Court's guidance on 6th of April. Justice Chandrachud, he set out a very detailed order explaining that these are the guidelines which one should follow. Video conferencing should be done till such time the situation improves. The only aspect which has been kept out of this order is recording of evidence. Unless consent, expressly consent, recording of evidence has been kept outside the purview of this order. Otherwise, the Supreme Court's order validates all of this. Now, with that background, I would give it back to Vyapak.
Sure. So I think that also answers one of the questions that Sugandha had, that how does the trial court's proceedings happen? At least what Supreme Court has said, that unless parties agree, evidence will not proceed on the video. But before we come to the other aspects and also hear Justice Sikri, one last question for Moazzam. Just to understand, we are now moving from urgent hearings to extremely urgent hearing. Moazzam, does that change anything so far as the urgency is concerned, or there is a threshold which is now very different when it comes to video conference hearings versus physical hearings?
So thank you, Vyapak. I think it's a very pertinent question under the circumstances. And well, there's a short answer to it and there's a long answer to it. So let me start with the short answer first. That yes, the considerations have changed a lot. So as all litigation lawyers would know that pre-COVID times, whenever you had a urgent interim relief, that would qualify. Basically take all the boxes for you to get a next day hearing before the court. But now that urgent relief has been prefixed with another word which is extremely urgent, and there's no set definition of what would qualify as extremely urgent. And because of there being a lack of definition of this terminology, we actually had to analyze all the various orders which have come in during the pandemic time, and basically analyze what kind of cases did the courts treat as falling within this bucket of broad bucket of extremely urgent. And what we found after our analysis was that at least till now, what qualifies as extremely urgent can broadly be divided into three broad buckets. The first bucket obviously is matters which are relating to the ongoing pandemic itself. So let's say matters concerning provision of protective equipment for doctors and medical personnel, deployment of security forces, free testing of government by government labs, so on and so forth. Matters concerning welfare of migrant workers in India and provision of midday meals during the times of pandemic, matters relating to repatriation of students and citizens of India stranded in other countries, matters requiring or rather dealing with or concerning prevention of contagious spread of COVID in prisons across India. So these are the matters basically falling in the first bucket, which deal directly with the pandemic itself and sort of arise out of the pandemic. The second broad bucket which we found was matters relating to personal life and liberty. So personal liberty matters, I mean bail applications. So, there was an order passed by the Honorable Delhi High Court which basically said that, which basically gave under trial prisoners the right to apply for interim bails and expressly provided that those matters, those applications for interim bails shall be taken into consideration by appropriate courts. The Rajasthan High Court had taken an opposing view that bail applications would not amount to, but that order was stayed by the Honorable Supreme Court. So which also kind of gives credence to the order passed by the Delhi High Court that at least bail applications are currently falling within the broad bucket of extreme urgency. And the other case was a matter pertaining to organ donation. It was also considered extremely urgent. So that's the second broad bucket, which matters relating to life and liberty. And the third broad bucket, which probably is the more relevant bucket for commercial lawyers, are certain matters concerning commercial interests falling within the broad bucket of extreme urgency. And there have been a spate of orders which have been passed during the pandemic period while the courts were operating on in the current fashion. And, they deal with, let's say, classification or a relief against classification of a petitioner's loan as NPA was stayed or stay was sought, and that qualified as an extreme urgent relief. some of you may be familiar with the order which was passed in the India Bulls versus SEBI matter, in which ICRA was the ICRA, which is a credit rating agency, was restrained from lowering the credit rating of India Bulls Housing Finance. The ground that was taken was that it would have extremely serious negative impact on the financial standing of India Bulls. So certain commercial matters also are falling in this broad bucket of extreme urgency. But I think the test which will have to be undertaken is how much hit are you going to suffer if you don't come and get a relief from the court then and there.
Sure. So thanks, Moazzam. Thanks for this background, and it brings to the right time for Justice Sikri to give his thoughts on this topic. And there are 2-3 broad thoughts, Justice Sikri, we would like to hear from you. One is the whole digitization of judicial system. You have seen the system for more than 2 to 3 decades now, and a lot has been done in the past, which only got expedited because of this COVID situation. Two, we are trying to address digitization and e-judiciary as part of the COVID system. And now, can we use this for, even future to even address some of the general problems that we have in judicial process? So we also read your article which got published recently on some of these topics, but we would like to hear your initial thoughts on how these things are changing, how litigation would work in India now and in future, and then we have more specific questions for you.
Thank you, Vyapak. Let me start by saying that how our judicial system presently is or plagued with arrears of the cases, where we know 30 million cases, 3 crore cases are pending in subordinate courts, high courts and Supreme Court. Of course, in Supreme Court the figure is only 50 to 60,000, but in the High Court it is about 40 lakhs, and remaining cases are in the subordinate courts. And the judicial system has been struggling with these areas. There have been various measures, various reforms, judicial reforms, which have been, such measures have been taken from time to time, and for last maybe 20 years or even more, that how to cope up with these areas. If I say that, look, there has been talk about increasing the strength of judges, because our judge population ratio is one of the weakest in the world. If we compare with the countries like America, England, or even China. And there have been discussions about alternate dispute mechanism, that why not divert most of or much of these cases to mediation and arbitration, etc., which has happened in America, where 19 to 95% cases are settled through mediation. So all these measures have been taken from time to time. Apart from that, what is more important from present point of view, which I want to state here, is that, look, for almost now 20 years, it has been realized that technology can play an important role insofar as tackling with these areas are concerned. After all, at the end of the day, when the courts are here to dispense justice, and justice has to be qualitatively and quantitatively both. That means that the judgment or the ultimate outcome of a case should be qualitative in nature. It should not be a mere disposal of the case, which may unnecessarily generate other litigation. I'm not dwelling on that in detail, but yes, we want quality justice, and we want quick justice as well. That the cases at present, which are in the system for years together, they should, the period during which these cases can be disposed of should be minimized. And for this purpose, as I am saying, apart from the other measures which I have said, technology, it has been realized, can play an important role and that is computerization, which had been taking place for last about 20 years, and it may say only in nutshell and only flag this point is that it may lead to, and it is leading to, after this has been imbibed, um, better court management, better case management, where there can be grouping of the cases of same nature. Now what happened, I remember when I was a lawyer, and if one instance, if I give it to you, in the matter of say excise matter, there was spate of, I think, hundreds of writ petitions which were filed in Delhi High Court. One writ petition on the same question, all these petitions were, which was decided in the year 1983 by a full bench of Delhi High Court. But that case which was decided, on that basis, more than 200 other cases should have been disposed of. But then in 1983, there was no such system of clubbing the cases and finding that if one issue is decided, how many cases are covered by that, and they should also be taken care of. And you will believe in it, I'm talking of now 2001 or 2, when I was a judge sitting with Chief Justice, and we disposed of those cases at that time, relying upon the judgment which was given way back in 1983. So in spite of the judgment in 1983, we disposed of more than 200 cases with one stroke, but after 20 years, which should have been decided in 1983 itself. So this is what the technology can do, as I'm saying, and there are various, how it leads to court management, how it leads to case management, that is how many cases should be there before the court so that the court is able to dispose of all, or at least deal with all these cases instead of giving unnecessary adjournments, etc. And a particular case, how that should be managed on the board of a particular judge. The technology facilitates that. Now, technology, after this, computerization of the system, e-filing has been there in various high courts now, and even in district courts, many district courts. Then even the court fee can be paid by e-means. And now question is that in the whole process, I'm not going to state much in detail, that but even video conferencing, some of the hearings have been taking place by video conferencing for last 10 years. And if I give you the example of Delhi, now that was limited to, up to now, as far as remand cases are concerned. Because in the morning, if you know, in any district court, whether it be Sazari or Karkaduma or other, from those who are in judicial custody or those who are in police custody, they come from there, from the jail, in buses in the morning. Then they are produced before the courts, various courts, and remand is given, and then they are taken back. Now, all that, if you know how much time it takes in the morning for the jail authorities to take the attendance of these persons, to bring them out, and then to keep them in safe custody in the court premises, and then take them back. Now, all this is obviated because by video conferencing, the persons are in the jail only, and that some lawyers would be there, maybe this legal aid lawyers, and the judge on video conference sitting in the court takes those remand cases, because these are otherwise routine cases. Now, this is one example which I am giving, which saves lot of expenditure and lot of time and energy, and lot of time of the court as well. Now, this was not, this video conferencing system was not utilized for other purposes. COVID has come. We are all scared of what is happening. Today we are grappling with this. As Vyapak mentioned about my article, where I said that 3 things which are badly affected are lives, because people are losing their lives, many of them, livelihood, that many have been rendered unemployed, and lifestyle. So I am not today talking of our lifestyle, because what I have said is that in spite of all this, life has to go on. After all, the front runner workers are doing their work. doctors are doing their work, then grocery, etc., which is necessary or essential items which are there, are doing their work. The guidelines which have been issued yesterday by the government, as per that, some of the essential services which are not interrupted and which and some of them, more of them, would be started from 20th April. I feel that the justice delivery system is also an essential service. Now, once we talk of justice delivery system as essential service, it should not be, or rather, it should go on uninterruptedly. These are unprecedented situations. Now, these unprecedented situations have at least this, I can say, that silver lining in the entire process, that it has jolted the entire judiciary or all the stakeholders, including that somehow at least those cases which Mr. Khan has also mentioned, the 3 kinds of cases which the courts are taking up, those cases should be undertaken, and those cases should be decided through the medium of video conferencing. Now, this is one aspect, that today, from urgent to very, very urgent matters which we are taking. Now, that may be an issue because as of today, it is said that court should, but at the same time, other cases are not being taken up. Now, these cases which Mr. Khan rightly said, that look, in the first category are the cases which are COVID related matters only, all that issues which have arisen because of that. Now, bail cases and even the third case, even third category, commercial, etc., most of these are the offshoots of, if you say, COVID, because RBI issued the guidelines that the account should not be declared NPAs during this period, etc., and it led to some litigation. Now, Bombay High Court has also passed the order that the position as on 1st March 2020, which was there, that of a particular account, that should not be altered. So, in a way, they are also COVID related, many of them. But the question is, this is now, as I said in the beginning, I see it from 2 perspectives. One is, when we are having this pandemic today, we are struggling with it, and during this period, when the social distancing has to be maintained, how the court should be run. And in the process, we have realized, and everybody has realized, that video conferencing and this technology can play an important role. If it is used, extensively and in a proper manner, then of course it should not be, that is the first thing, that during this period we are using it. But the second aspect which I want to highlight is why it is a permanent feature or a permanent fixture. Why the hearings should not take place even in normal times through video conferencing wherever they are necessary. Now, it may lead to so many advantages, if I say so, as was pointed out by Mr. Banerjee as well, that how the hearings nowadays take place and how the matter can be listed. Now, first of all, compulsorily, almost the filing is it is an e-filing, and before the hearing starts, before that, of course, at this stage it is e-filing, but then as per the guidelines which are issued by 5th April order of the Supreme Court also, which they said that, look, you file your arguments as well, and there can be a hearing which can be a limited hearing for 20 minutes, 30 minutes, or whatever. If we translate it to normal times as well, according to me, it may avoid unnecessary adjournments. Suppose a witness, as we said that today, Supreme Court order says that it would not apply to the as far as recording of evidence is concerned. Suppose it is applied, and even in normal times, then the witnesses who have to come from other states, they need not physically travel to a court at distance place. They can be examined on video conferencing. It may entail, it may save so much of cost and so much of time as well. Sometimes a particular lawyer or the particular person is not able to physically appear in the court, because of which adjournments are given. But if the person can argue it from sitting in his office or in his at his residence, a lawyer, those hearings can take place and adjournments would be avoided. It will lead to more transparency, and transparency more so if I give the example of Kerala and Bombay High Court, where they have allowed live streaming also. So live streaming of the court, where the other persons can also watch the court proceedings, even when they are physically not present, and whatever is happening. And so therefore, it may, according to me, result in that kind of reforms which I started with and with which we are struggling. It may go a long way. So therefore, what I feel is that in the beginning, yes, very, very urgent matters, because we are undergoing these trying times. But we do not know how much it will continue. It was for 3 weeks. It has been extended by 19 days more, up to 3rd May. We do not know after 3rd May also what is the situation. It will depend upon what is the, what are the conditions, how many people are suffering, whether, still isolation or social distancing is required or not. It will all depend upon that. But then suppose there are relaxations, but it is not the social distancing, which is the advice given by the government today, is or by the medical profession, cannot be totally discarded even after 3rd May. And then there are other restrictions also. There are restrictions on travel as well. Why not in those at second stage, there should be, as far as matters are concerned, from very, very urgent, it may come to all urgent. After all, during vacations, when there are summer vacations or even winter vacations, urgent matters are heard. There is a category of cases, 7 or 8 categories of cases, which the high courts or the Supreme Court, they list that these kinds of matters can be put. So why not in second stage, we go to all those kinds of matters instead of very urgent matters. And in the long run, as I said, it may bring judicial reforms if it becomes a permanent fixture and the technology is adopted. What is needed is at the end, and that is the caveat, is that look, not only judges have to hone their skills, upskill and learn new skills, and even lawyers have to cooperate with that. I may tell you from my example that today I am not a sitting judge, but I am a sitting judge as far as Singapore International Commercial Court is concerned. We had one hearing on 1st April, where one judge was sitting in the court in Singapore, other judge me from Delhi in my house, and third judge from London. So we 3 judges were at 3 different places, and the one lawyer from Singapore who appeared in the court, and the other from Malaysia. So he was in Kuala Lumpur and the hearing took place. And arbitration world is also now thinking that the arbitration hearings should go on through video conferencing if this state of affairs continue. But as I was telling, up to 14th April, most of the cases we had adjourned. After 14th April cases which are coming before me, and I am requesting the lawyers to do it through video conferencing. As of now, very few have accepted. But therefore, mindset of the lawyers have also to be changed. That is what I say.
Sure. So I think you have possibly answered a couple of questions which are already on the chat window. One of them, which Madan Sharma had asked, as to what kind of cases can go on each platform permanently? Can it be extended to arbitration? I think you have already answered that. But there is also one very good suggestion by one Dhananjay, where he says, can we have a permanent court fixed in Supreme Court to hear on video conference throughout the year? Because if people cannot travel, at least there can be some category of cases if both the parties agree or one of the parties agree to video.
Yeah. Vyapak, I think this is very good suggestion. And if I give a parallel example of e-courts, particularly Delhi High Court started it, and even today in Delhi, I think there are 9 or 12 e-courts today. So those courts, at that time, it was meant that they should be paperless courts. Of course, lawyers come there physically, they appear, and there are no files, etc. and hearings. It is e-courts, everything, and entire file is on computer. So which can be then upgraded to video courts. So like when e-courts are established, and there are many other courts which are not e-courts, but few courtrooms have become e-courts in Delhi High Court. Likewise, as is suggested by Dhananjay, if one court can be video court, in not only in Supreme Court, in each High Court also, and all those cases can be transferred to that court of that particular day, where the lawyer or witness is not able to come physically, and why not those hearings should go on. It's a very good suggestion according to me.
So with that, there is also one question which possibly goes along with it as to, and possibly only you can answer that as a judge, as to how do you see the demeanor virtually, right? Because sometimes you see at the time of taking evidence, the credibility of the witness, you see him or her physically and the demeanor and how things are functioning, and he or she may say something, but the credibility is decided based on the person sitting in front of you. Do you think that's a little bit of a problem in this whole virtual system, or
no,
people will adopt to that as well?
I think my answer is, I will give two answers to this, and saying that it may not be an obstacle. Number one answer is that the demeanor, if a person is appearing and you can see his or her face, and when the questions are put, and the concentration can be on the face, focus can be on the face of the witness, so that the judge is able to see the demeanor. After all, whether it is seen when the person is actually present, or if it is seen when the person is present virtually before the judge, and his facial expressions can be read. That is one answer. Second, which is more practical answer, is, let me tell you very frankly, and it is being discussed. Of course, demeanor is very important. There is no doubt about it. But if we go by the harsh realities, in how much cases this demeanor plays the role because of delays. Today, one judge records the evidence. Gone are those days where when we talk of session trial, what is the meaning of session? The court is in session, and the technical or literal meaning is that session will continue till the trial ends. So it used to be, when it was given the nomenclature session trial, that the trial which takes place on day-to-day basis, as it happens in movies, day-to-day, and that is what is meant by session trial, day-to-day basis, whether it goes on for 5 days, 6 days, and at that end, immediately thereafter, arguments start and the judgment is given. But today, it takes months together, sometimes years together, in recording the evidence, whether it is a civil case or a criminal case. And a particular judge who has recorded the evidence may not be the judge at the time when the arguments are heard. So what is the role of demeanor in any case? In 80 to 90% cases, the judge who has recorded the evidence would not be deciding the case at the end of the day. So therefore, that is another reason because of which we should not, for this reason alone, discard video conferencing. Sure. Recording of the evidence to video.
Sure. There are other issues, and maybe you can also give your thoughts as to how to implement this as we go along. I think one question is also in reference to the procedures of filing, as to what kind of signatures are required, what kind of documents to be filed. I think some of them are already taken care of in the e-filing rules. But what more can be done, particularly, learnings from Singapore and other courts. And I at least have a personal experience way back in 2008 or 9, when we had filed one section similar to a Section 9 petition in Singapore court. I'm talking about more than 10 years back. And we filed it overnight from India. And next day, we even got an SMS that hearing is fixed between 12 to 1, and timings were fixed. They were, chess clock timings even for the courts, so far as Singapore litigation is concerned. Do you think those kind of things, which are always looked at it from a perspective of natural justice, anybody can take any much of time, There is no case management in terms of how much a case would take, so that the second case can come. Because in video conference you will have to allot time. You cannot sit in court and
what I
wait for your
said.
matter.
Yeah.
So what's your thought? What is the cultural shift, and what are the kinds of regulatory shifts that we may require to bring in some of these aspects?
You see, that is what I said, and at that time when I said that what are going to be the advantages of proceedings through video conference, and one of them was that saving of time, where if once we adopt it and it becomes a necessary, I would not say evil, but rather necessary advantage, that the lawyers would not take that much of time. Let me tell very frankly, one example which I always give when I go to law schools and during moot court competitions. I tell lawyers, I tell those students that one thing which lawyers should learn from you. If you see in the moot court competitions, if you know, they are given 40 to 45 minutes each team. They are, most of the time I have seen the problems are very complex, not that very easy case is given to them. And the manner in which that proceeds, that they have to file their testimonial or their memorials, they call written memorial, that is, which are written submissions. And I have seen most of these written submissions, those student lawyers hard, because they know that ultimately it depends on what they are writing there, because they would be given only 40 minutes at the time of arguments. When at the time of arguments they are given 40 minutes, and in 40 minutes they have to explain all the facets of a case. So therefore, one thing which is good is that the memorials are of very high quality. Other thing, that rationing of time, they know that in 40 minutes, they have to speak everything, and they plan it accordingly. Why not lawyers also learn from there? From this attitude of the students in moot court competitions. We know in America, in Supreme Court of America gives 30 minutes of their written arguments filed there by all the parties, then 30 minutes to each party, each advocate which are given. And even I've seen they so strictly observe it, even if a judge has asked a question to a lawyer, and lawyer is answering that question, and although he has not been able to complete the answer, but the time finishes, he stopped. He's not even allowed to complete his answer, which he is giving in response to the question put by the judge. So that kind of strictness is there. But what I feel is, and let me be very frank, from my experience as a lawyer also, I was a lawyer for 22 years, then judge for 20 years. We have the tendency somehow in India to go on and be very much repetitive. Of course, many times a lawyer thinks that, look, I have to hammer this point again and again till the judge understands. Sometimes the manner, the way the perception of understanding is, till the time I'm able to convince him that what I'm saying is correct. So that is where the problem lies. Ultimately, you have to, see that you have made your point. It is for the judge now to decide. Of course, we need judges also of very high caliber and quality judges to understand those arguments. Say that it goes the other way as well. And but it may bring that kind of, I would say, culture in Indian courts, where everything, and particularly in the High Court and Supreme Court, and where the matters of moments are there, constitutional matters, etc., are there, that the written submissions would be filed. That can be e-filing again, which would be of high quality, coupled by the limited time which is given. And coming to your first part of this question, when you said of filing of the cases, etc., and taking care of you rightly said, it's not only Singapore, many other jurisdictions also which have adopted this system of e-filing. We can see what are and the Supreme Court also gave that hint when it said that not the recording of evidence, because there have to be proper rules framed for that purpose. Tomorrow somebody may not say that some such and such provision of the Evidence Act is violated, and therefore the entire evidence goes for a toss. Maybe keeping in view these kinds of constraints, the court felt that until and unless there are proper rules framed for recording of evidence, etc., which take care of the provisions of Evidence Act also, and procedure, whether it is civil procedure or criminal procedure also. And but then such kind of rules are there in place in Singapore and in many other jurisdictions. So we can always take help from there and formulate our rules so that it becomes a permanent fixture. And going by what was suggested earlier, that at least in the beginning, one court can be video court, where this experiment can start on permanent or regular basis.
Sure. I think there is also sometimes concern on the parts of the litigants as far as confidentiality is concerned, or in terms of sanctity of documents exchanged electronically, because there is no proper checking of documents, or even while taking evidence, whether the person is prompted or when the documents are filed, whether they are authenticated or true copies, or they are tampered with in terms of electronic filing in electronic forms. Have you come across any experience around it and learnings from the other jurisdiction as to what kind of systems that we can now adopt? Because I think those are broadly some of the questions from Nilima and Shubham and others in the chat window that I'm seeing, but I'm just trying to summarize some of those questions.
No, let me be frank, I have not come across so far. I mean, my experience in Singapore, no case has come up so far. I do not know. I'll now look into it, how they deal with this. But then let me, for time being, an answer to this could be, in those cases where the court is faced with such a situation, then first of all, there can be a mechanism before the evidence is recorded, can be provided, where all these things are checked by the court staff, along with lawyers, as far as authenticity of documents, etc. is concerned. That can all be checked before the case goes for trial. And because we are talking of trial, when the trial takes place, witnesses coming on video conference. So before that, these things can be checked, as we have the system of discovery, we have the system of interrogatories, etc. also in recording the evidence. And if you know, and you know it, Vyapak and others also, I hope they know it well. Insofar as arbitration is concerned, international arbitration, it has been going on. Recording of evidence through video conferencing has been going on for last number of years now. And in commercial matters particularly, there's not much dispute insofar as documents are concerned. In commercial world today, the way documents are exchanged on emails or otherwise, so as far as authenticity of documents are concerned, there's not much dispute. So we can start with those kinds of cases where the possibility of this authenticity, etc., or the dispute on authenticity is minimal. So we can start with this, and insofar as even in other cases are concerned, then all these things can be checked, according to me, before the case comes up for trial, if it is the documents of one party or the authenticity is questioned by the other party.
Sure. I think there is quite a few questions, one from Divyang Majmudar also and others, on the time limit for the advocates, and you touched upon it a little bit in your earlier answer, but we want to know from you as a judge, because you have been sitting as a judge for 20 years now. Is that judge is not able to curtail the advocates for long arguments, or is it like people feel that they have not got the justice because of that, or it is just that nobody bothers and it's just repetitive arguments, or it is very easy to just tell advocates to fix time so that everyone knows how much long this will take, and the next case and the next case and so on?
Let me tell Vyapak, all this, what you have different thing, is it this or this or this or this? According to me, all these are the reasons. And at the end of the day, it depends upon the judge. I've seen there are judges, and you also must have seen, who will sit quietly, would not even put a question, and would say it is the right of an advocate to argue as much as that advocate wants to argue. So they will not disturb the advocate at all, and it may go on even for days. They will keep on hearing. And then there are other kinds of judges you have seen, I won't name, that there's there few judges in even in my Delhi High Court I had seen in those days that they would come, and now I'm talking of other extreme. They would come, they have already read the case, they would not allow the lawyer even to speak. Sorry, your case, either there's nothing in the case or this is the case, and after giving 10 or 15 minutes, they will start dictating the judgment. There are those extreme cases also. And then there are judges, and I would, according to me, I think the best method or the best judge in these circumstances would be who should give time to the lawyer to argue, because if I have read the brief beforehand, that doesn't mean that I know the case thoroughly. As a judge, I am saying, because it is the advocate who has to argue the case. And when we read the files beforehand, we read the files only because of the reason that the docket is heavy. There are so many cases. If we start reading in the court, then we will not be able to take up all the matters. But at that time, I mean, as far as I'm concerned, I had always felt like this, and I had been telling my colleague judges also, read the file so that you have the flavor of the case, but don't make up your mind on that. That let us see that in the court. Of course, prima facie mind may be there. I'm not talking of SLPs. SLPs one knows by the time all the, I mean, it has come maybe 2 stages or 3 stages, and you know that there's hardly anything, and it may be dismissed in 2 seconds also, 3 seconds also. There are those cases, because 70 to 80% cases are just like that. But in other cases, or even in appeals, etc., where the leave is granted, suppose, and at high court level, other level, we read the case, we read the judgment which is impugned. On that basis, prima facie view, but then give a chance. Chance means chance to say, complete chance, whatever a lawyer wants to say. But at the same time, regulate the timings, which can be in various forms. Okay, you tell what are the propositions. Either written arguments are filed in the beginning, or at least propositions in the beginning, 3, 4, 5 propositions in which the lawyer wants to argue. Then after the lawyer has argued one point, at that says, yes, I have understood, this is the point you want to say, and on that, now you please go to this. So at that time, you control the court, control the timings during which the lawyer should make his submission by, in a way, I would say by at least satisfying him or her that, look, what you want to say in respect of this point, I have understood. And this is what I used to do sometimes. After this argument, look, you want to say this, I'll summarize that argument in 1 or 2 minutes, from which the lawyer would get that I have understood. I would say, look, I have understood. What I'm going to decide whether I accept the argument or not is a different thing. This is what you want to say, that I have understood. So therefore, that would, at least the lawyer would get satisfied that, yes, what I wanted to say has been said. So therefore, it should be this middle path where the lawyer is given a chance to argue. After all, nowadays, particularly when the stakes are high, and when it comes to Supreme Court, it is the final court. There's no further appeal thereafter. So therefore, no lawyer can take a chance. The stakes are high. Lawyer has also taken a huge fee, if I may say so. The client is sitting in the gallery there, and the client should not get an impression that, look, my lawyer was not even heard. That means that as if the lawyer, this judge, doesn't bother about this lawyer. So therefore, we should give full respect to the legal profession and the lawyers community as well. But at the same time, it is the judge who has to control the proceedings. And if the judge is good and he is effective, then the judge can always control the timings. This is what I say.
Sure. So I think there is one more question which I think Alipak touched upon in terms of the order on limitation by Supreme Court. Maybe Alipak, you may want to just answer that question as to how this limitation period would get addressed. And then Moazzam, you may want to also clarify if you have any point on limitation point, and also on the issues of the other video conference taking of evidence We have about 3-4 minutes, and then maybe we'll go back to Justice Sikri for some of the other questions.
Thanks, Vyapak. I think to give a very short answer, there's no clarity on that. But we would assume that the intervening time till such time the lockdown is lifted and the courts come back in regular form, that intervening time may be excluded from the regular timeline stipulated under the different statutes. Supreme Court order doesn't clarify. Maybe we'll get a clarity, but as things stand,
Sure.
That's the view that we can take.
Sure. So I think that possibly answers Vega's question, Rishi's question. But Moazzam, do you want to add anything on this or the aspects which Justice Sikri mentioned, particularly based on your experience in international litigations and arbitrations?
Sure. So I think just on the limitation point, I completely agree with Alipak. I think the only reasonable interpretation which can be given to this Honorable Supreme Court's order is that the period of COVID will be excluded in computing limitation, and there will not be a last day rush. So let's say the restrictions are lifted at the end of April, and on the 1st of May, everybody has to, file their relevant filings. I don't think that is how it's going to play out. It's reasonable enough to assume that. And plus the Supreme Court's order itself clarifies that the limitations shall stand extended with effect from 15th of March till further orders to be passed by the Supreme Court. So it contemplates two things, like one, the limitation stands extended, and two, Supreme Court will pass further orders in this regard. So at least on the first point, I think I completely agree with what Alipak said. On the other point, I think, at least on the video conferencing and video trials, and I've been seeing the questions which have been coming in, I think one must learn from, what the other countries are doing and the mistakes which the other countries did, or the good things which they're doing. I think, I believe Justice Sikri mentioned how, so many cases are getting settled in the US and are diverting to arbitration, mediation. And I think one big reason for that, at least in the US, is pre-trial depositions. And pre-trial depositions happen only on video. But, they don't happen in a courtroom. All parties get together in a conference room. There's no judge sitting. So counsels from both sides, parties from both sides are sitting together in a conference room, and that session is being recorded over video, where one party's lawyer will ask the other side's witness a question, and all of that gets recorded. And this is all pre-trial. So essentially what happens is, both sides get to know the strengths and weaknesses of their respective cases and settle. As a result, you're declogging the entire court system when you're moving the trial out of the court. So that's one, an important learning which we can probably take from the US. And obviously, it's been in the US for a number of years, and they take great pride in in that fact that their pre-trial depositions lead to so many settlements and so on and so forth. I think another question which was there on the panel is that internet may not be as penetrating in India, and therefore a lot of these opportunities may not be best utilized. And this is just my personal belief, and this belief comes from the fact that I actually do a lot of online gaming, all those games, PUBG and all of those things. As a result, I end up interacting with a lot of these multiplayers, coming from different villages all over the world, all over the country. And what I realize is, I think internet is far more penetrative in India than right now our judiciary is.
Yeah, you are right.
So, and technology is a great enabler, right? So take full advantage of it. And I think that's it. That's all I have to add.
So I think we are unfortunately coming to the close of the 1 hour session, but maybe some final words from you, Mr. Justice Sikri, or Nishith bhai, if you are there, if you want to close, and then I'll hand it over to Khaled.
You see, as I said earlier also, this is COVID-19 is one pandemic with which everybody is struggling. As of today, we have not found any answers. Of course, it will go. We know that human being and we will triumph. But then this period has taught us so many lessons. We are talking of, look, nature is in this rebooting mode. It is reviving itself, and what we had been doing, we are taught a lesson of that. We have today realized that Almighty, which is the supreme and not the human beings, etc. So in that way, in that sense, yes, there is a purification of soul, and insofar as other things are concerned, and then the people have started thinking much about their relationships, etc. So that is one part. But as we said, and I said in my article also, that the silver lining is of this, that it can now boost much or many judicial reforms which were up to now awaited or were going on a slow pace. So let us take advantage of that, and let it not be a fixture what we are doing it today only for this period, that is during the period COVID-19 lasts. It should then go beyond and become a permanent feature. We have discussed how it can be so, and how it can be at least to start with one court in each of the say institutions, Supreme Court or High Courts or District Courts, video conference courts, and which over a period of time can be then expanded. So my appeal to the legal community is that cooperate. My appeal to all the judges would be that don't think, and particularly in the Supreme Court, then because in Supreme Court almost all the judges with the exception of few would be in their early 60s, that no, it is no time for us to learn now this new technology and why we should be doing it, because that was one reason because of which e-courts could not become 100% in all the courts e-courts. And in Supreme Court also the system is in place, but e-courts are not functioning in that matter. In that manner, I had been saying to my colleagues at that time when I was in the Supreme Court. So it is a time to then learn new skills, and to even learn new things which are coming in our way, and this kind of maybe a traumatic experience insofar as sitting in the houses is concerned, and we are not going out. But then whatever people are, there are those who may be whiling away this time watching TV all for 12 hours a day, and there are people I know, and I know one of the judges of the Supreme Court, and there may be more, who are writing books, who are writing articles. I am reading books, I am reading articles. We are utilizing this time. You see how it has created this now just so many this spurt of activity insofar as webinars are concerned, insofar as conferences on Zoom are concerned. I had one, I'm the director of Insol International, which is having its headquarters in London, and we have the board of directors of 17 or 18 people who are spread throughout the world. So yesterday only we had that conference. So why not, when these things are now becoming, at least during this period, becoming so common because of necessity, then why they should not become the normal activity even after COVID goes away?
Sure. Thanks a lot. With that,
thank you very much.
Positive message.
If I may interrupt, sorry to include in the excellent panel, and Justice Sikri, you spoke so well. It was very well. In fact, you said that there may be no solution to COVID, right? And at the same time, there are problems, but we can have solution to our problems, So yes. COVID takes some time to be solved. But all the problems that we talked about, including in the litigation side, we are finding solutions. And we had solutions. We had never had an urgency to solve those problems and use those solutions. and nature has its own way of compelling us to learn things. When it comes to, you end up doing what you think you'll never do it in such a short time. So it was wonderful session, and I don't want to stretch this session time too much. But thank you, Vyapak. Thank you, Moazzam, Alipak, and Justice A K. We hope to have you again
Thank you,
sometime.
Nishith bhai. Thank you. Thank you.
So nice of you to have been with us, and thank you.
Congratulations to Vyapak organizing all this thing and his entire team, Moazzam also and Alipak also, and keep this going.
Thank you.
Thank you. Thank you. We had about 60 sessions by this time in 3 weeks' time.
Oh wow!
Yes. And
Really remarkable. I congratulate you for that.
100% commitment is on education at this point in time.
Yes.
With this, I think I would leave audience,
Sure. Thank you.
Sayonara and see you again.
You want to? Sure. Khaled, do you want to? Yeah.
Thank you so much. I would like to thank our guest speaker, Mrs. Justice Sikri. Thank you so much for joining us, and all the panelists, DC, Alipak, Moazzam. Thank you so much. I would also inform our attendees about our events. So today at 6, we have our webinar on 3D printing, the new frontier legal and tax issues. That will be at 6 p.m. today, as well as at 9 p.m. there will be how to litigate patent disputes in India. So this session will be at 9 p.m. today, and if you want more information about it, please do go to our website as well as on LinkedIn. There are links available. And thank you so much, everyone, for joining in. You may disconnect your lines. Thank you.